I'm Allie.
I'm Bob. We're from Charlotte. We've been married for 34 years.
Has it been that long?
Yes, it has.
Wow. And we have two great kids and 5 grandchildren.
When I retired, I was ready to enjoy life and be carefree, spend time with the grandkids, enjoy our vacation home, play lots of golf, the usual. But when my wife's father passed away, we saw how complicated things can get if you're not fully prepared. We thought, well, he had a will, so it'd be easy, right? But everything had to be officially sorted out. The paperwork, the estate taxes, distributions among the family. It was far from simple and easy.
I was the executor of my father's will. He left money for the great-grandkids who are minors, and let's just say it created a mess I was not ready for. So we found Simpson Law Firm, and we were a bit nervous going into the office because we had never done this before.
As soon as we walked in, we felt welcome. The team was absolutely amazing. The probate attorney walked us through everything step by step. She explained the whole process and how long it would take, which really calmed us down. It wasn't just about handling Dad's estate, it was about helping us to feel like we could handle this.
She took the time to really understand what was important to us and what my dad's legacy meant. She listened to us and made it clear that we were not alone. Knowing we had the whole team by our side, the process was less daunting.
Now, through this process, we realized how unprepared that we were for our own future. We thought we had plenty of time to get our affairs in order, but going through probate opened our eyes. We didn't want our kids and grandkids to deal with the same stress and confusion when that time comes.
So we started thinking, what about us? And once we saw how caring and knowledgeable that they were in handling my father's estate, we knew we wanted to stay with them to build our estate plan.
We worked hard our entire lives. We have our home, our beach house, our kids and grandkids. We wanted to make sure our wishes are clear and that everything we worked for goes exactly where we want it to.
With Simpson Law Firm as our planning partner, they made planning so much easier. They guided us through every decision, every detail. We left feeling lighter knowing that our family is protected and they won't have to go through what I did.
They gave us peace of mind and clarity through a plan that was built just for us, knowing that our family is protected and nobody is left to pick up the pieces alone. It's really been a blessing.
So when I meet with couples like Allie and Bob, my initial meeting with them, we kind of just get to know them and obviously extend our condolences to their family because not only are they going to have to go through the probate process, they are grieving the loss of a loved one. We're here with them every step of the way and we'll make sure it is done properly and in accordance with the laws in North and South Carolina. The estate administration process is what we refer to as probate. Oftentimes people think that a will is enough in order to avoid probate, which is actually not a correct information at all. The fact of the matter is that wills are actually drafted in order to submit to the probate court in order to ensure that the last will and testament are submitted and then distributed according to the decedent's wishes. Basically, we take all of the information that we're given regarding the estate and we obviously fill out the paperwork and ensure it's filed in the way in which is proper. And then we also know different places to look because not all families know where loved ones' assets are. We just kind of try to give people an idea of where to find the information initially because sometimes it's not always in a pretty little binder waiting for the right time. After all obligations are satisfied, whether compromised or paid in full, the estate distributions can then be made to the beneficiaries. While we don't do probate litigation, we do assist the family with navigating those troubled waters sometimes with family dynamics. As the estate administration attorney, I'm the attorney for the estate. I don't represent any of the beneficiaries or even the personal representative if they are a beneficiary. I make sure that the fiduciary does what they're supposed to do. While not every estate is the same because every family is different, every personal dynamic is different, the way people hold their assets or transfer their assets or the kind of assets they have are different. And so we really try to tailor our approach for every client differently because every client has different needs. While the probate process can seem like a burden or even scary, that's the value that we provide to our clients is we give them that relief so that way they don't have to be alone and so that when the estate is closed, there's nothing left to be done. When people come to our office, obviously it's because they've lost a loved one, and whether it's expected or not, it's a lot to deal with. And dealing with the business side of dying can be overwhelming, and it can be just that added layer of hurt for them. And so we really meet people where they're at. Well, a lot of clients that come in to get estate administration assistance turn into estate planning clients because they realize that their loved one either didn't plan at all or had some shortcomings in their particular plan. And so when they have to live through the ramifications of those documents or not having those documents, it becomes a real thing to them, and they realize very quickly that they need to get their affairs in order, either update their documents or get a plan put into place.
It's fairly common for couples to come in for EP after having experienced some sort of EA matter or estate administration. When we have folks come in, we want to make them feel at home. So the first things we do, of course, is greet them and invite them to sit down with us in almost like a break bread fashion. One of the first things we want to do is get to know them a little bit and ask them some just general questions about what brings them to us and ultimately how can we help them. For estate planning purposes, a lot of the conversation is objective based. So we want to talk about what's important to them and ultimately try to get a good idea of what sort of legal tools might be available to them to achieve those objectives. If we're thinking about someone like Allie and Bob, oftentimes the first consideration for them is how can we avoid excess taxation? How can we avoid getting hemmed up in probate? And what are some of the ways or the tools that you have that we can achieve these objectives to ensure that interests that we have worked hard for will pass down to our loved ones in the most efficient way and the most cost-effective way. Oftentimes when someone loses a loved one, that's the prompt or the impetus behind they themselves getting their own plan in place or taking those first steps to really think about perhaps probate isn't the way that we want to go or the process that we want to leave our kids to have to deal with. And so oftentimes we'll look at and explore alternatives to a will or to the probate process, which almost always leads to some sort of trust work or trust design. The process does contemplate and include, I think, the consideration of someone's total net worth. There are certainly talking points and subject matter topics that we need to address concerning taxation in particular and the federal estate tax. Notwithstanding those factors, I think that much of the design for trusts in general can apply to everyone. The trust can serve the basic function of allowing those interests to pass outside the scope of probate, which is ultimately what we want to do is one of the main utilities that the trust offers. Beyond that, just like any other instance for estate planning, there is no one-size-fits-all for estate planning. But I do think that there are some very standard and necessary inclusions that will be part of any estate plan. Though there's some concern about leaving an inheritance to a minor. But the main point is that you want to try to take steps to avoid naming a minor directly and instead use alternatives that can better serve their interests. It's very important to consider ultimately the effect of what's going to happen if you do name a minor child in your planning documents. And how that will prompt a series of events that will follow that lead through the court process. Right? Estate planning really serves the purpose of allowing you to implement the people that you trust, put them in the decision-making roles that you want them to be in, and you get to set the rules of how those things would work. Well, I think having an estate plan is important for everyone. It's not just for the high net worth individual. It's not just for the person that has a minor child or a disabled individual in the family. It's important for everyone because that's your opportunity to be proactive and take steps to memorialize your wishes and ensure that you have something of legal significance that's going to make sure that that's carried out. And so we're all better served, and it would only promote our own interests to have an estate plan in place. I'd encourage anyone that has had any sort of experience related to estate planning, whether it's their parents, whether it's someone that's passed away in the family, whatever's prompted you to consider that or think about that, give us a call, reach out to us. We'd be more than happy to meet with you, talk about what options are out there to address your specific needs, and find the best way to go about putting that in place so that you and your family are best served.